A Supreme Court decision just came down that completely blindsided legal experts on both sides of the gun debate. And here's the thing nobody's talking about. This wasn't just about your Second Amendment rights to own a gun. This was about your First Amendment rights to even talk about guns. And if you don't understand what just happened, you could lose both rights without even knowing it. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal involves two Supreme Court cases that just rewrote the rulebook for gun owners in America. And 90% of gun owners have no idea this even happened. Hit that subscribe button right now so you don't miss what comes next. Because this information could literally be the difference between keeping your rights and watching them disappear. So let's talk about what just went down at the highest court in the land. In June 2024, the Supreme Court handed down not one, but two landmark decisions that will impact every single gun owner in America. The first one, United States versus Rahimi, was an 8-1 decision that shocked everyone. The second one, NRA versus Vullo, was actually unanimous, 9-0. But together, these two cases just changed the game for how the government can regulate both your gun rights and your right to speak about guns. And here's what makes this so important. Most people think the Second Amendment is just about owning firearms. But what these cases reveal is that your First Amendment right to talk about guns, to promote gun safety, to advocate for the Second Amendment, that's just as much under attack as your right to own the firearms themselves. Let me start with the 8-1 decision that everyone's talking about. United States versus Rahimi. This case involved a guy named Rahimi from Texas. Now, Rahimi was subject to a domestic violence restraining order. Under federal law, specifically Section 922 G8 of Title 18, if you're under a qualifying domestic violence restraining order, you can't possess firearms. Rahimi challenged this law, arguing it violated his Second Amendment rights. And here's where it gets crazy. The Fifth Circuit Court of Appeals actually agreed with him. They said that based on the Supreme Court's previous decision in a case called New York State Rifle and Pistol Association versus Bruen, this gun restriction was unconstitutional. The Bruen decision from 2022 said that gun regulations have to be consistent with America's historical tradition of firearm regulation. The Fifth Circuit looked at history and said, we can't find enough historical precedent for disarming people subject to restraining orders. Therefore, this law is unconstitutional. But the Supreme Court reversed that decision 8-1. Chief Justice John Roberts wrote the majority opinion, and here's what he said. When an individual has been found by a court to pose a credible threat to the physical safety of another person, that individual may be temporarily disarmed consistent with the Second Amendment. The court looked at historical laws going back to the founding era. They found surety laws and going armed laws that allowed for temporary disarmament of individuals who posed a threat to public safety. The court said these historical analogs were close enough to support the modern law disarming domestic abusers. Justice Clarence Thomas was the only dissent. He argued that the majority wasn't being faithful to the historical analysis required by Bruen, but 8 justices said, no, this gun restriction passes constitutional muster. Now, here's why this matters for you. The Rahimi decision clarifies something really important. The Second Amendment is not unlimited. Even after Bruen expanded gun rights, the government can still restrict firearm possession for people who pose a credible threat to others. If you're subject to a domestic violence restraining order, you can lose your gun rights, period. But here's the key detail that everyone's missing. The restraining order has to include a finding that you pose a credible threat. It can't just be any restraining order. It has to be one where a court specifically found that you're a danger to someone's physical safety. This is actually a more narrow ruling than people realize. It doesn't give the government blanket power to disarm anyone with any restraining order. There has to be a specific factual finding of dangerousness. Now, quick legal note. This is educational information, not legal advice. If you're facing a restraining order or any situation involving your gun rights, you need to consult with an attorney who specializes in this area. Every case is different, and the specific facts matter tremendously. Don't rely on a YouTube video to make legal decisions about your situation. Always get professional legal counsel. Now, let me tell you about the second case, and this is where your First Amendment rights come into play. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the 5 words you should never say to police when they ask if you're carrying a firearm. Subscribe right now so you don't miss that video. It could save you from accidentally incriminating yourself. Okay, so the second case is called National Rifle Association versus Vullo, and this one was decided unanimously, 9-0. Every single justice agreed on this one. Here's what happened. Maria Vullo was the superintendent of the New York Department of Financial Services. After the Parkland school shooting in February 2018, Vullo allegedly used her regulatory power to pressure banks and insurance companies to cut ties with the NRA. According to the NRA's lawsuit, Vullo met with executives from Lloyd's of London, a major insurance company. During that meeting, Vullo allegedly told them that New York would go easier on them for unrelated regulatory violations if they stopped doing business with gun rights organizations, especially the NRA. Vullo also sent out guidance letters to banks and insurance companies. These letters encouraged financial institutions to consider the reputational risks of doing business with the NRA and similar gun promotion organizations. The letters urged these companies to take prompt action to manage these risks and promote public health and safety. Now, on the surface, that might sound reasonable. But here's what the NRA alleged. They said Vullo was using her government power to coerce private companies into punishing the NRA for its pro-Second Amendment advocacy. The NRA argued this violated their First Amendment rights. Why? Because the government can't use indirect pressure to suppress speech it doesn't like. If the government can't directly censor you, it also can't threaten third parties to cut you off and silence you that way. The district court agreed with the NRA and denied Vullo's motion to dismiss. But then the Second Circuit Court of Appeals reversed. The Second Circuit said Vullo's actions were just permissible government speech and legitimate law enforcement. The court said the guidance letters were written in an even-handed, non-threatening tone and were just trying to persuade, not intimidate. But then the case went to the Supreme Court. And here's where it gets interesting. All 9 justices said the NRA stated a valid First Amendment claim. Justice Sonia Sotomayor wrote the opinion. She said that a government official cannot use the power of her office to punish or suppress disfavored expression. The court relied on a case from 1963 called Bantam Books versus Sullivan. In that case, a state commission tried to suppress publications it found objectionable by threatening distributors with potential criminal prosecution if they didn't stop selling certain books. The Supreme Court said that violated the First Amendment. The government can't threaten people to achieve censorship, even if the government is not directly ordering the censorship. Justice Sotomayor said the same principle applies here. The NRA plausibly alleged that Vullo threatened to wield her regulatory power against insurance companies and banks that refused to aid her campaign to punish the NRA's gun promotion advocacy. Vullo allegedly told Lloyd's of London that she would go easier on them for unrelated violations if they cut ties with gun groups. That's coercion. The message was clear. Help us target the NRA or face stricter enforcement. The Supreme Court said that if these allegations are true, that violates the First Amendment. Now, this doesn't mean the NRA automatically wins the case. The case was sent back to the lower courts for further proceedings. Vullo can still argue qualified immunity. She can still try to prove the NRA's allegations aren't actually true. But the key point is this. The Supreme Court said that using government power to coerce third parties into suppressing speech is unconstitutional. So what does all this mean for you as a gun owner? Let me break it down into practical takeaways. First, from the Rahimi case. If you are subject to a domestic violence restraining order that includes a finding that you pose a credible threat to someone's safety, you cannot legally possess firearms. Period. This is now settled law by an 8-1 Supreme Court decision. If you violate this, you're committing a federal crime. You could face up to 15 years in federal prison. Don't mess around with this. If you have a restraining order against you, talk to a lawyer immediately about whether you need to transfer your firearms to someone else or turn them into law enforcement. Do not take chances with federal gun charges. Second, understand that the Second Amendment has limits, even after Bruen expanded gun rights. The court has made clear that dangerous individuals can be temporarily disarmed. The court is looking for historical analogs, but they're willing to accept regulations that are relevantly similar to historical laws, even if they're not identical. So if you're in a situation where you might be considered a threat to public safety, your gun rights could be restricted. Hey, here's a crazy stat. Only 12% of people watching this video right now are subscribed to this channel. That means 88% of you are at risk of missing critical updates about your gun rights. Don't be in that 88%. Hit that subscribe button so you never miss a video that could protect your rights. Now, here's the third takeaway, and this one's huge. The government cannot use backdoor tactics to suppress your pro-gun speech. The NRA versus Vullo case makes this crystal clear. If government officials are using their regulatory power to pressure private companies into deplatforming gun rights organizations or gun rights advocates, that's unconstitutional. This has massive implications beyond just the NRA. Think about payment processors like PayPal or Venmo. Think about banks. Think about insurance companies. Think about social media platforms. If government officials are pressuring these companies behind the scenes to cut off gun rights groups or gun businesses, that violates the First Amendment. Now, proving this kind of coercion is difficult. You have to show that the government official's communications could reasonably be understood as a threat or as coercive inducement. But the Supreme Court has made clear that this kind of jawboning, as it's sometimes called, can violate the Constitution. Fourth takeaway. Document everything. If you're a gun rights advocate, if you run a gun business, if you're involved in Second Amendment activism, keep records of any unusual actions by banks, payment processors, or other service providers. If they suddenly cut you off, Ask for a written explanation. If there's any indication that government pressure was involved, that could be the basis for a constitutional claim. Fifth, understand the distinction between persuasion and coercion. The government is allowed to criticize the NRA. Government officials are allowed to say they disagree with gun rights. They're allowed to express their views and try to persuade others. That's government speech, and it's protected. What they can't do is threaten adverse regulatory or enforcement action to force third parties to suppress speech the government doesn't like. That crosses the line from persuasion to coercion. Here's the part that should really concern you. These cases reveal just how much pressure is being applied to gun rights from multiple angles. It's not just direct gun control laws anymore. It's financial pressure, it's social pressure, it's regulatory pressure. The anti-gun movement has figured out that if they can't ban guns directly, they can try to strangle the gun industry and gun rights groups by cutting off their access to banking, insurance, and other essential services. Operation Choke Point 2.0, some people call it. But now, thanks to NRA versus Vullo, we have a legal precedent that this kind of backdoor censorship is unconstitutional. This is a huge win for the First Amendment and the Second Amendment. But here's the thing. The fight's not over. This case goes back to the lower courts. Other cases like it will be filed. And gun owners need to stay vigilant. This information could literally change the legal landscape in the next 12 months. Subscribe now because my next video breaks down exactly what you need to do to protect yourself if you're ever targeted by these kinds of tactics. Don't wait until it's too late. So let me give you the bottom line. The Supreme Court has spoken on two major cases affecting gun rights. In Rahimi, the court said people under qualifying domestic violence restraining orders can be disarmed. 8-1 decision. This is a limitation on the Second Amendment, but it's a narrow one. It only applies when a court has found that you pose a credible threat. In NRA versus Vullo, the court said unanimously that government officials cannot use coercion to suppress pro-gun speech. They can't threaten third parties to cut off gun rights organizations. That violates the First Amendment. Together, these cases show that while gun rights are strong, they're not unlimited. The government can regulate guns in some circumstances, especially for dangerous individuals, but the government cannot use its power to silence pro-gun advocacy. Your right to speak about guns, to promote the Second Amendment, to run gun rights organizations, that's protected. And any government official who tries to use backdoor pressure tactics to suppress that speech is violating the Constitution. Here's what you need to do right now. 1. If you're subject to any restraining order, talk to a lawyer immediately about your gun rights. Don't guess, don't assume. Get professional legal advice. 2. Stay informed about these legal developments. Gun rights law is changing rapidly, and you need to know what's happening. 3. Support organizations that are fighting these battles in court. The NRA, the Second Amendment Foundation, Gun Owners of America, these groups are on the front lines defending your rights. And 4, document any unusual treatment you receive from financial institutions or service providers, especially if you're involved in the gun industry or gun rights advocacy. Look, I spend hours every week researching court decisions, reading legal briefs, and breaking down complex gun law so you don't have to. The least you can do is hit that subscribe button to support this channel and make sure you never miss an important update. Deal? Because here's what's at stake. We're living in a time when gun rights are under unprecedented pressure from multiple directions. Direct legislation, regulatory pressure, financial deplatforming, social stigma. The enemies of the Second Amendment are using every tool they have. But we have tools too. We have the Constitution, we have good lawyers, we have favorable court precedents, and we have cases like Rahimi and Vullo that clarify where the lines are. But you have to know where those lines are. You have to understand your rights, and you have to be prepared to defend them. So here's my final thought. The Supreme Court's decisions in these two cases show that the justices are trying to find a balance. They're saying, yes, gun rights are fundamental, but they're also saying, no, gun rights aren't absolute. Dangerous people can be disarmed. At the same time, the court is saying that gun rights advocacy is protected speech. The government can't use coercion to silence it. This is actually a pretty reasonable middle ground if you think about it. We can keep guns away from people who pose a credible threat to others. But we can't let the government suppress speech about guns just because some officials don't like the Second Amendment. That's the framework we're working with now. And as a gun owner, you need to understand it. You need to know where you stand legally. You need to know what rights you have and what limits exist on those rights. That's what this channel is all about. Giving you accurate, up-to-date, no BS information about gun laws so you can protect yourself and your family. All right, let me wrap this up. Two major Supreme Court cases just came down affecting gun rights. Rahimi, 8-1, says domestic abusers under qualifying restraining orders can be disarmed. NRA versus Vullo, 9-0, says the government can't coerce third parties to suppress pro-gun speech. Together, these cases define the current state of gun rights law in America. Know your rights. Know the limits. Stay informed. And for God's sake, subscribe to this channel so you don't miss the next major development. Because I promise you, more cases are coming, more legal battles are brewing, and you need to be ready. Thanks for watching. I'll see you in the next one.